One of the most contentious aspects of the Kyle Rittenhouse case is the gun charge, because many progressives, leftists are saying no matter what happened that night, no matter who is at fault, Kyle Rittenhouse is guilty because he was in the process of committing a crime and self-defense does not apply in this regard. Wrong, not true. And if that was true, there wouldn't even be a trial. But ladies and gentlemen, we have big news. It appears the judge has agreed finally with the defense that Kyle Rittenhouse was legally allowed to keep and bear that rifle, which effectively means, it should be tossed out, but the judge stopped short and said he was going to provide his instructions to the jury. He's going to provide the defense's request for instruction to the jury. I don't know if this means the defense has won across the board, but it certainly seems like, based on the rhetoric the judge has provided, he is going to give instructions to the jury which say, take into consideration the provision that says the law only applies if you are under the age of 16. Okay, I got to slow down here. I got some tweets to show you. I got an article from Andrew Branca, the injustice of the gun charge against Kyle Rittenhouse. This goes out. Kyle Rittenhouse very well may be acquitted of all charges. But I don't think the judge is ready to toss the whole charge. I think the judge wants to give a full set of instructions to the jury. And there was a lot going on here. You're going to love this. The state said to the judge, Your Honor, the law makes no sense. And the judge said, if it makes no sense, you're out of luck. How is a regular person supposed to live their life if the law as read makes no sense? In which case, how could a judge instruct a jury to enforce a law that makes no sense against someone who is abiding by the statutes of that law? Long story short, we have all long since argued the gun charge against Kyle Rittenhouse is incorrect. Initially, after the night in question, I said, the law plainly reads you cannot have a dangerous weapon under the age of 18. And then I said, if he's in the process of committing a crime, I don't think he's going to have a strong defense because someone might say he was committing a crime. I was wrong. Talk to experts, and they said, read the exemptions. Only if you are under 16. Amazing. Now, this may actually be a technicality that the law was broken, but I do think you can read the law and understand, as it's being drafted, what the legislation of Wisconsin meant when they created this law. To put it simply, a law gets drafted and says you can't have a weapon under the age of 18, a dangerous weapon. And then it goes to committee and they all discuss it. And someone says, what about if I'm going hunting with my kid? Your kid could be 12. And they say, okay, all right, well, if you're supervising your kid and you're hunting, this won't apply to you. And someone said, come on, my 16, 17-year-old kid can't go out and hunt. It's Wisconsin. There's tons of rural areas. And said, oh, okay. So you have to be in violation of both of those provisions, basically. It makes sense. Meaning, if you are under, this is my understanding, if you're 15, but with your dad or parent hunting, you can bear a gun. If you're 15 and with your dad in the middle of a street with a rifle, you can't. If you're 16 or 17, you are allowed to bear a long gun. Let me show you some of what's going on. This is all breaking right now. I had to push back my normal recording schedule because I'm sitting here listening to the live testimony, and it looks really, really good for Kyle Rittenhouse. Check it out. We're tracking Andrew Branca's commentary here. I think he's actually one of the best. He's an expert on self-defense, and he's got a full breakdown of the gun charge. So I'm going to read to you the injustice of the gun charge. You may have actually, I did talk about it the other day, but this is extremely relevant because this could pull the rug out from the entire case. Look, many leftists have come out, progressives, Democrat, whatever, saying, I realized I was wrong about Kyle Rittenhouse. He was defending himself. But to maintain the narrative, what we're seeing from still many Antifa activists, because they want to win, is, yeah, well, he was illegally possessing a weapon. Many people on Twitter have consistently said crossing state lines with a gun. Not true. He did not do that. And so once the news became irrefutable and everyone said, okay, he didn't cross state lines with a gun, they changed it to he crossed state lines and illegally obtained a gun. No, he did not. Law of self-defense. Andrew Branca tweeted. I want to go through some of these tweets because I want to show you what the state was saying. It's amazing. Looking like Judge Schroeder is going to toss the gun charge. That would be the correct decision on these facts. The only correct decision on this charge on these facts. The judge is not biased. I wish he was. The left keeps saying he's biased. The judge didn't throw the charge out. He just said he's going to give the jury the full statute. The jury is likely going to acquit. But the judge, as a question of law, should say, Kyle's not under 16. This law you can't charge him with a crime. It's remarkable. Think about it this way. Let's say there was a law that said in order to be charged with jaywalking, you'd have to cross the street while not in a crosswalk. And then the state charges you with the crime of jaywalking and tells the judge he was in the crosswalk, but it was at the wrong light. How can you charge someone with a crime when you know it does not apply to what just happened? Okay, let me read more of this. From Andrew Branca. Krauss, the ADA, says, if you accept the defense's reading of the gun law, the law makes no sense. And the judge says, if it makes no sense, you, state, are out of luck. The law does make sense. It's not hard to understand. The problem is the judge is sitting up there, not biased, trying to understand both arguments. And then the law is being read by the defense accurately. It says there's two provisions you must be in violation of, and Rittenhouse was not. The law was specifically crafted with exemptions. Think about it this way. If you're under the age of 18, you can't have a handgun. If you're under the age of 18, but at least 16 or 17, you can't have a long gun. Let's put it this way. Are you familiar with Romeo and Juliet laws? You as an adult cannot engage in adult activity with someone under the age of 18 in many states. However, most states then have a provision called a Romeo and Juliet law, which states if the person is within X amount of years of the individual, this law shall not apply. To put it simply, if you are 18 years old and you are a mature adult and you are having adult relations with someone who is 17, a minor, in many states, the strict reading of the law is you're abusing a child. But we've crafted Romeo and Juliet laws because we're like, dude, if the guy's 1 month older than his girlfriend, that is not abusing a child. And these cases have come up, which is why we have crafted these exemptions. I remember going over a story out of Illinois where a guy was like 6 months older than his girlfriend. They were both 17, but the family hated the guy. The day he turned 18 and their daughter was still 17, they called the police, and the police said a strict reading of the law states if you're over the age of 18 engaging in adult activities with someone under the age of 18, you have committed the crime of statutory. You get the point. And it's a travesty of justice. No one crafted the law expecting an 18-year-old and 17-year-old with only a few months of each other's birthday to have their, no one believed that should be a crime. In fact, in some states, it's 3 years, meaning an 18-year-old can be dating a 15-year-old. I'm kind of like, that's pushing it, isn't it? Or a 19-year-old and a 16-year-old, or a 20-year-old and a 17-year-old. And once you're 18, it's off to the races. But exemptions are added to the law after the fact. The law will say something specific. What the prosecutor is trying to do is instruct the jury to ignore the relevant portion of the law. The judge is not having it. Shira Fisa, the defense, said, I argue the hunting language is irrelevant. Simply says there is an exception, period. Our client qualifies for that exception, and the judge said it does say that. This is why I think it's annoying when the left is like, the judge is biased. If the judge was biased, he literally agrees with the defense the gun charge should be thrown out and then doesn't throw it out. He's going to give it to the jury. Krauss, the prosecutor, says the title of the statute says person under 18. And even then the judge says the rubric title is not part of the statute. I don't even know why I have to keep saying it over and over again, but I think this is very, very significant. At this point, it should be clear to everyone from the get-go, there's an exception in the law so that a 16 and 17-year-old can bear a rifle on their own. Why? Because a 16 or 17-year-old can go about defending themselves and their property or hunting or going to the range. And not only that, Kyle Rittenhouse testified that the reason he believed he was legally allowed to possess the rifle in Wisconsin, not purchase, but possess, was because police told them that. Now, ignorance of the law is not an excuse for breaking it. But I certainly think at this point, the judge should have just tossed it out. You're telling me the reason you had the rifle is because you were told by officers you were allowed to. Yes. And when you showed up to this night in question, the police said, "Hi, thanks for being here." Yes. Every step of the way. And a strict reading of the law says, as someone who is 17, you are it specifically says the law does not apply to you. I tell you what, man, this is crazy. The judge says, this is where it gets confusing. My intent is to submit what defense submitted. Their gun charge jury instruction. State must prove under 18 and that dangerous weapon was a rifle, shotgun, etc. Okay. The defense's instruction was to look at the relevant exemptions. All right. I want to break down for everybody. I know I've talked a lot about this, but we're going to go in depth on the self-defense as it relates to whether he has a gun illegally. I want to read you what Andrew Branca, Law of Self-Defense, has to say about this so we can just stop the arguments. Because I go on Twitter and all these leftists are like, yeah, well, he illegally had a gun, so therefore, no, there wouldn't be a trial if that was true. Well, the gun was illegal anyway. No, that's a question of law for the judge or question of fact for the jury. It's not definitive. Although I think it's fair to say it is definitive, I'm saying the judge did not say as such and still won't give it up. From Legal Insurrection, in an article titled, "The Injustice of the Gun Charge Against Kyle Rittenhouse." First, he writes, self-defense applies to Kyle's most serious criminal charges. The primary legal defense raised by Kyle is self-defense. That legal defense of self-defense is applicable directly to the charge of first-degree intentional homicide of Anthony Huber, count 3 of the criminal complaint against Rittenhouse with a mandatory life sentence, and attempted first-degree intentional homicide of Gage Grosskreutz. The legal defense of self-defense is also applicable, albeit indirectly, to the charge of first-degree reckless homicide of Joseph Rosenbaum, count 1, 60 years, and first-degree reckless endangering of unknown male jump kick man. In that a justified use of force against an intended target is by law necessary and reasonable and therefore not reckless. And both of those men were actively attacking Rittenhouse and therefore presumably intended targets of his use of force. Right now, what we're talking about, the bigger picture here, is the jury instructions. Because the question of law is for the judge. He then tells the jury, if the law states these provisions, read them, then you must determine whether or not the burden of proof has been met by the state. And if you believe beyond a reasonable doubt he's guilty, then you can choose guilty or not guilty. If the jury is given instructions which include a provision that says if you are 16 or 17, it doesn't apply to you effectively, then the jury has to come back with a not guilty verdict. Let's read some more. He says, and also I'll clarify too, there were arguments as to the lesser included charges. So they're saying, okay, if it's not a first degree murder, is it a second? If it's not first degree reckless homicide, is it second degree or first degree reckless endangerment? The crazy thing about this, because the judge is not biased, the judge was like up for the jury to decide. And he's basically saying that if someone attacks you and you have a gun to defend yourself and you fire, you are potentially reckless because you fired your gun without checking your surroundings. I think that's insane. The defense argued, if you are acting in self-defense, you do not create a reckless circumstance. And they're trying to argue attempted reckless endangerment. And the defense was like, how can you attempt to be reckless? Anyway, let's keep reading about the self-defense. They say, it's somewhat more ambiguous to what extent the legal defense of self-defense covers the charge of first-degree reckless endangering with respect to journalist Richard McGinnis, good for 12 years, who was somewhat behind Rosenbaum and arguably endangered by the gunfire. Of course, criminal recklessness requires the risk created be an unjustified risk. A justified risk is not sufficient, in which case Rittenhouse wasn't trying to hurt Richie McGinnis. Richie McGinnis did not fear Kyle Rittenhouse and did not flee. Kyle Rittenhouse fired only to stop the threat before him. He was justified in his use of force. I do not believe, and I'm friends with Richie. He's a good dude, and I do not believe he was intentionally put in danger. I'm glad he's okay, but he clearly wasn't scared of Kyle because he knew Kyle was being attacked. He goes on to say, the relevant question in the case of McGinnis' reckless endangerment charge will be whether the risk created towards McGinnis was unjustified and therefore reckless. We get it. Ambiguous gun charge and treacherous jury instruction. Check it out. He says, this still leaves one charge, count 6, the possession of a dangerous weapon by a person under 18. under 948.6A2. This is a mere misdemeanor charge and is punishable by up to 9 months in jail. The gun charge has indeed become a sticky wicket, largely because of the alleged ambiguity created by the Wisconsin legislature in drafting the statute, by the failure of the relevant Wisconsin criminal jury instructions to accurately reflect the plain statutory language, and by the fecklessness of the prosecution in the case. I will pause here and say, in terms of this right now, initially it seemed that the judge was only going to allow jury instructions on the 2A, the standard statutory reading, and not include the exemptions. It now appears the judge said he's going to give the defense's version of the jury instructions, which will include the exemptions and likely result in an acquittal. Complicated, not a lawyer, and I may be getting this wrong, but based on everything I've read and what I've been hearing from other lawyers and what the judge himself said, it seems like he's inclined to defend the defense. Perhaps by over the weekend, he will issue his hard ruling and provide that to the defense for their arguments on Monday. He says, because of Kyle's claim of self-defense, compelling against the felony charges against him is irrelevant. Compelling against the felony charges against him. Let me just omit that. Because of Kyle's claim of self-defense is irrelevant as a defense to this particular misdemeanor charge. There is no self-defense justification for willfully violating a gun possession law. Section 2A, which is what the defense wants to be read strictly with nothing else. Any person under 18 years of age who possesses or goes armed with a dangerous weapon is guilty of a Class A misdemeanor. If that was the only statutory language that applies to Kyle, it's pretty much an open and shut conviction. He was admittedly under 18, and he was in possession of an AR-15 style rifle, which certainly qualifies under Wisconsin law as a dangerous weapon. Indeed, the jury instruction that has been drafted specifically reflects this apparent simplicity of construction. And that's why it's important. Let me see if I can pull up this tweet where the judge says, I'm looking for it. The judge said, my intent is to submit what defense submitted. Their gun charge jury instruction state must prove under 18, and the dangerous weapon was a rifle, shotgun, et cetera, et cetera. Andrew Bronca says, very confusing. But it sounds like what he's saying is the defense's version will be given to the jury, and thus the judge agrees with the defense. Check it out. Here's what he says. The simplicity of construction, defining for the jury elements that the state must prove beyond a reasonable doubt to find a verdict of guilt. The defendant possessed an object. The object was a dangerous weapon. These are both true. The defendant had not attained the age of 18 years at the time she allegedly possessed a dangerous weapon. All of those are true. He says, again, if that's the entire analysis, Kyle's guilty. However, that is not the entire legal analysis. There's more. And it is found later in the same statute in paragraph 3C. It says, this section applies only to a person under 18 years of age who possesses or is armed with a rifle or shotgun if the person is not in compliance with SS 29304 and 29593. So unless Kyle was not in compliance, that is, violating these provisions, the gun possession statute would seem to not apply to him at all, and the judge seems to agree. So what are these provisions? He says, the second of those, 29593, sets out the conditions that must be met to be certified to engage in certain hunting activities. With respect to these conditions, the state correctly points out that Kyle has not met any of these conditions, and therefore they argue he's not in compliance. The first defense counter argument here could be that 29593 applies to hunting activities and Kyle was not engaged in hunting activities. Therefore, it won't apply to his circumstances. In fact, the defense literally said, Judge, we concede on all the hunting charges. But here's where it's important. He says perhaps a stronger counter argument is the plain reading of 3C says it applies only if the person is not in compliance with 29304 and 29593. It does not read or. That means both must be in violation. So even if Kyle can be said to be not in compliance with the hunting provision, was he also not in compliance with the other provision? In 29304, we see that it is also a hunting-related statute, but one that involves restrictions on hunting and the use of firearms by persons under 16 years of age. Wait a minute. How can Kyle not be in compliance with the statute that only applies to a person under 16? He was, after all, 17. Well, that's precisely the position of the defense. Basically, you must be in violation of the first one, hunting, and the second one, under 16. It's not entirely clear, but I think I can reasonably determine, and I think a fair person would. What the legislature was trying to say is, if you're 16 or 17, you can bear a rifle. if you're under the age of 16, hunting under supervision, you can you can have a weapon. Otherwise, you can't have a weapon under these specific ages. So if you're not in violation, I'll put it this way. If you are 15 years old and you are not hunting, you are now, I'm confusing myself on this one. To put it simply, you can't be not in compliance if he is exempt from, he cannot be in compliance with SS 29304. If he cannot be in compliance with 29304, he is exempt from 948.6A2. The judge agreed. Now, I'll be fair. I think the law makes no sense. I think it was written poorly. I think it was written very, 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 very poorly. And I think the general assessment is that if you're 16 or 17, you can have a long gun, and the police even seem to think so. And that's what Kyle Rittenhouse testified to. Now, just because a cop says it's legal doesn't mean it is. But I think it would be a travesty of justice for the law to read as it is and for that to be used to criminally prosecute Kyle Rittenhouse, who was 17. I don't think it's relevant for the most part to the case. I think we're talking about the loss of life and self-defense. So you have to be in violation of both of these provisions, meaning if you are hunting but under the age of 16, you are fine. If you are not hunting and you are under the age of 16, you have now violated both provisions, and it is a crime. If you are not hunting and you are over the age of 15, 16 or 17, 18 or whatever, you are not in violation of both provisions, which means you are exempt if you are hunting and young, or you are not hunting, but at least 16 or 17. I think it's actually pretty easy to understand. I've had many people message me saying that up in Wisconsin, they'd go hunting when they were 12. And that's it. You are not in violation of both. Therefore, you are exempt. They could have written the law better, but I think this is a major win for Kyle Rittenhouse. I'll leave it there. Next segment's coming up at 4 p.m. over at youtube.com/Timcast. Thanks for hanging out, and we'll see you all then.